All right, in this video, we're going to go over the Illinois listing paperwork. So when we go to sell your house, there is a stack of paperwork we have to fill out, and this video will give you a detailed explanation of what all these different forms are and what they say in detail. So this video is going to be about 45 minutes. It really gets into the weeds, but watching this video in advance will just give you an understanding of what this paperwork says, and then at the time of when you're there filling out paperwork, it'll just accelerate, make everything go a lot faster. So you can understand what the paperwork is in advance, and then when we're there, we can just fill it out and then move on with getting your house on the market. So what are these different forms? And we'll give a summary here, and then we'll dive into the weeds on each one. So we have the listing agreement. We have the disclosures. There's 3 disclosures in Illinois: the property, the condition report, property condition, lead paint, and radon disclosures. We have the MLS Exemption Form, so the 3rd one, and then the 4th one, there's 2 different forms here, is their brokerage disclosures. They're for affiliated business, and they're for wiring fraud. All right, so let's dive right into these documents. All right, document number 1, the first one, the most important one, the marketing agreement. This is the agreement to be able to list your house for sale. So how this gets filled out here is brokerage name. I'm with eXp Realty. That would go here. Managing broker name. So that goes by managing broker. Designated agent. So that's saying that I'll be the one working to help you sell your home. The designated agent there. Seller 1, seller 2, husband, wife, or if it's a company name or trust name, that would go in here. 7 here, seller represents and warrants that title of the property is in the name of. So it's just saying how the name of the property is taken, because it could be in a different name. Property, so in the sections 9 through 14 here, this just describes the property legally. So the address, the unit number, city, county, state, zip code, the PIN here, permanent index number, and if it's the information here talks about if there's a condo, co-op, townhome, the parking space would be included. If yes or no, is it a deeded space, limited common element, assigned, and then the parking space number. So here lists the term and conditions. So we fill in the date the listing agreement starts, the date the listing agreement ends. Going on to section 22 here. This is one that's the sellers will initial here to just state that they will not discriminate against anybody based on race, age, color, religion, sex, ancestry, order, protective status. So this just goes through the different protected classes and states that the sellers will not discriminate against anybody for those reasons. Item 3, marketing price. So that's just the price we are going to list your home for. Possession states it's written in possession to be negotiated at time of sales contract. So that's written in. If we want otherwise, there's a section later on that we can add a note to. It's pretty typical that possession changes at closing, but it would be spelled out as to any differences to that. Like I have a contract right now where there's a sale and lease back where the closing is actually pretty quick. It's like 3 weeks from contract date, and then the buyer is leasing it back to the seller for up to 3 months while they find their next house. So that's working out well for them. This just states seller's designated agent. So here it just states who. That's my name goes here. This states that, again, because the agreement's between eXp Realty and you as the seller, and this just states that I'll be the one working with you, and that if needed, others in my brokerage can help out. Cool. All right, item 6, possible dual agency. So what this section is just talking about, that dual agency would be if, say, we have your house listed for sale. There's, as an example, there's a sign in the yard that has my information on it. Somebody calls me and says, hey, I'm interested in this property. I'd like to tour it, and they call and I'm helping them get information. So dual agency means when a realtor is helping both the seller and the buyer on a transaction. So this just spells out my moral, ethical, and legal obligations. It basically states that I have to be honest with both people, but I wouldn't give the buyer a inside scoop information that might help them. Like, let's say there was a extenuating circumstance and the seller would just take, if they would just take any offer or something like that, then this just states that I would not tell them those things, but I could help encourage a buyer to place an offer. Maybe if they were on the fence and I knew the seller really needed an offer just to move on with life, I could tell the buyer something like, hey, I know the seller is looking at all offers, so let's go ahead and put one in and see what happens. But it wouldn't, for either side, it wouldn't give anybody any inside knowledge as to anything of that would give an unfair advantage in a negotiation. That's kind of what this goes on to say. So here you check yes for that, or for some reason that wasn't going to work out. Let me check no here, initial both sides here. This is for both sellers. All right, number 7, representation of buyer. It's kind of a funny one where it's kind of an obvious one where it states that agents from my brokerage may be working with buyers that might be interested into your house. So it's kind of a obvious one there. All right, item 8, buyer confidentiality. States that I or someone from my brokerage may have worked with a buyer previously that gives us inside knowledge as to a buyer, and this just states that anything that was confidential of the buyer, that we would keep that confidential in the transaction. So like, let's say I knew history about a buyer, about their family matters or things of that nature, that I wouldn't disclose any secrets about that buyer to you as the seller. And again, you can keep a conversation going between a buyer and seller, but just not disclose any secrets. So all this is kind of circular language here. All right, item 9, managing brokers affiliates. There's another kind of funny one. This just states that, again, like I'm with eXp Realty, that states that another agent with eXp Realty may be the one that brings a buyer to buy your property. And so again, it's just stating that because we're with the same brokerage, that it's just disclosing that the other agent would be representing the buyer as the buyer's agent, and then I representing you as the seller's agent. Again, kind of obvious language there. But all right, item 10, consent to represent others. There's another kind of obvious one. This just states that as a real estate agent with their brokerage, that either our brokerage, managing broker, or designated agent would be me, that we may represent other clients or will be representing other clients at the same time during this transaction. It's just an obvious one to let sellers know that, me as your agent will be working with other people on other transactions at the same time. Another kind of obvious one. Section 11 here talks about the brokerage fee. And so how this is that the brokerage fee will be the percentage that it is here, listed here, and then it'll be distributed as a percentage, part of it to my brokerage and then part to the buyer's brokerage, and that split just gets referenced here. And then this last part just talks about when the commission would be due. So per the contract, it's that when the house is for sale and there's a contract put together with the buyer and a seller, then as long as everything goes as the contract should, the house would close and then commission would be paid at the closing. This just states that once a contract is put together, if the seller were to decide just not to sell, then a commission would still be due to both the buyer and selling agents. And if there was reasons to need to stop a sale, there's right ways to do that. So if that ever comes about during a transaction, we can work that out. It's just that you wouldn't want to just say, we decided not to sell. So there have to be a reason, and there's ways to make that happen. But that's just saying what this just talks about when a commission would be due. All right, this section B here talks about a commission being due if the property is sold to a buyer that went under contract during the time that the property was marketed. And this is kind of an obvious one, but this happens like sometimes people will have, for various reasons, need to have a very short listing agreement of say like 3 months, and say in month 2 a deal gets put together between buyer and seller, and then it just takes 45 days to close. Then the closing date would happen outside of when this listing agreement was the contractual dates. Just states that a deal that was secured during this contract time, then the commission would be due even if the closing happens outside of the end date of the listing agreement. And 109 here is just special compensation information. So if there was anything unique to how compensation is, that's very rarely ever gets used. Item 12 here speaks that the listing brokerage has say as to how the buying side's brokerage is compensated, and that's usually that's just straightforward, where it's a preset percentage of the sale price. So I've never had anything outside of that happen. Not to say there would never be, but that's what this section says. All right, item 13 here. This goes into the details of information that's shown on the intranet, basically during listings. This section here just talks about what information from the listing is shown on the the different internet websites, and here kind of drills into those different details. So like 126 says, I do or do not want the property listing to be displayed on the internet. So I usually recommend that would be that you do want the listing on the internet, so you wouldn't check anything here. 127, I do not want the property address to be displayed on the internet. That's one that I usually recommend not checking, because you do want the address shown. And then for these next two, 120 and 29, I usually recommend that we do check that, because this states that you do not give permission for comments or reviews on the listing, and you do not want any automated estimated valuation of their home listing. I usually check that, because then otherwise what could happen is that one of these other websites could put a value to the house that, could be wrong and show way less, and it just, why have that on there? And then this is that's something that could be like on some websites could have comment strings, like, somebody could just make some rude comment and then just follow from there. So it's just best to not go down the path on these, has been my experience. 130 to 132 just states that the seller acknowledges and understands what they've signed above. It has a title, insurance, and survey. So this first section just talks about that the owner has not added to the property or gained any easements in favor or against the property. And so this just states that basically that there's been no changes to the property, unless, there can be, and that's fine. It's just that there would be nothing that more than meets the eye. Like sometimes an easement may have been recorded across a property, and this would just be the time that would be brought up. And then this next section here talks about that for title insurance, that the seller agrees to provide the buyer a title insurance policy. And then also that not less than 1 business day before closing, except for if it's a condominium, the seller may be required to provide a plat of survey dated no more than 6 months prior to closing. And so that would show all the setbacks and any encumbrances on the land. It just is all standard of Illinois. The survey shall show all corners staked and flagged or monumented. So that would mean that the surveyor comes out and actually marks the corners of the property. Or if it's pie-shaped, they put in different pins there. All right, so here this section talks about title insurance, and it just gives the options of seller authorizes brokerage to order title insurance through seller's behalf, or seller directs that you have a certain vendor that you want to provide the title insurance. Or this one is usually the direction that we go, where the seller's attorney will make necessary arrangements for title insurance and any related services. So in Illinois, it's pretty typical that the attorney would just work with their preferred title insurance vendor, and they work together. That's just kind of how that works. All right, 15 just talks about the items that are included. And so all the fixtures and personal property stated within are owned by the seller. So you go through these and just check everything that stays. And then, yes, unless other thing is noted, seller agrees to transfer to buyer all fixtures, heating, electrical, plumbing systems together with the following items. And so this is generally saying that anything like attached to the house stays. These items here generally aren't attached, but that's just confirms that what would be staying, and I won't go through all of them for the sake of time. You can read through, refrigerator, oven, range, all that good stuff, washer, dryer. So if it's staying, we just check the boxes. Other items included, sometimes there'll be things like, gas grill might stay or what have you, or items not included. This would be a common one is like a chandelier or some sort of family heirloom that's attached to the house, or some shelving sometimes people like to take with them. So basically, if it's connected to the house, it's assumed that it's going to stay. And so if not, then it would have to be listed out here. 171 to 172 is where you list out anything that's a fixture, systems, personal property in the agreement. If anything of that stuff is not working properly, then you would make comment here. And there's also a disclosure later that kind of spells that out later, but that's what the spirit of this section is. And this is a good definition. A system or item shall be deemed to be operating condition if it performs the function for which it is intended, regardless of age, and doesn't constitute a threat to health or safety. So if it's working, it's fine. It doesn't matter if it's a HVAC system that's 20 years old. If it's working, it's working. All right, so 175 here talks about home warranty. And so this just states that if the seller does agree to provide a limited home warranty, and if not, we just strike through it. General experience is that home warranties aren't needed unless there's some sort of special situation. And then usually if a buyer wants one, they'll either ask for one or buy one themselves, but that all does happen during the transaction. So a buyer would order it during the sale process, in escrow as we call it. And so sometimes they'll ask a seller to pay for it, or sometimes they'll just pay for it themselves. All right. And 178, the disclosure, states a few different things here, kind of different buckets of thought, is that when somebody reaches out and maybe calls a general eXp Realty phone number, that those questions would be directed to me to follow up on whoever's inquiring about it. Then this goes on to say that the information we receive from you as the seller is we're assuming to be true and accurate, and that we will disclose that information for like marketing stuff as to, like new roof as a 2019. If you told us it was 2019, we would assume that 2019 was accurate. Also talks that seller agrees to comply with the provisions of Illinois Residential Real Estate Property Disclosure Act, the Illinois Radon Awareness Act, and the lead-based paint disclosure regulations. And we'll get into that. There's 3 different disclosures that are attached to Illinois listings, and we'll go through those. Also states that the seller understands that the seller may be held responsible for latent defects of the house that weren't disclosed. And this is all stuff that's like to the best of your knowledge. If you have a finished basement and there's a crack in the concrete that you don't know about because you can't see it, then you're not responsible for that. But if there's something that you do know about that you didn't disclose, then you could be liable for claims, disputes, litigation, judgment, or costs. So that's kind of what the spirit of this comment is. All right, section 18, limitations. The section states that the job of the brokerage is to effect the sale of the property, and that the brokerage and realtor representing the sale is not responsible for the property itself. So, yep. So section 19, minimum standards. They are very minimum. So this states that the minimum standards of a real estate agent or the brokerage representing the sale, that there are 3 minimum standards, are that they will accept delivery and present to the client offers and prevent counteroffers in negotiations. 2, assist the client in developing communication, negotiation, presenting counteroffers back and forth as needed until an agreement is signed and all contingencies are satisfied or waived. And 3, answer the client's questions relating to the offers, counteroffers, notices, and contingencies. So obviously that's very minimum. We offer way more than that, but that's just saying what the minimum standards of the real estate agent is per the contract. All right, marketing authorization. There's a couple different schools of thought in this one, and one of the main one is that it states that the seller agrees to let the brokerage, mainly me as your agent, market the home many different ways through the MLS, through our own advertising, through our own marketing, all the stuff we do to get your house out there and to get people interested and excited about it. States that it's not a requirement that the seller allow the use of a key box. We talk about that at the listing presentation. It gets in the weeds a little bit here. And lastly, this states that us as the brokerage representing you has an obligation under the MLS rules to provide information we have about the house to other agents so that they can market the property to their house. Because I guess the spirit of this is that there has been cases where listing agents have not wanted to disclose details or not put the house on the MLS right away because they're trying to find their own buyers to try to get both sides of the commission. So this is just stating that, hey, as soon as you have the listing ready, then you need to put it in the MLS and you need to advertise it fully so that other brokers can then advertise the property to their clients and bring people through the home too. Taxes and assessments, section 21. So this just talks through the details of taxes, assessments. So it's saying that all taxes and usually prorated expenses shall be prorated to the terms of the sales contract. So most usually any assessments or taxes are prorated through the day of closing. So in Illinois, usually you're like a year plus back on taxes. So like you could have the previous year's taxes to pay, and then say the closing happens in February. So there'd very likely be all of the previous year's taxes due, and then 2 months of the current year. So the math would be done to prorate the tax amounts. The seller shall disclose any assessments or special taxes. So like in a condo, there might be a special assessment on the books, and so the seller would need to disclose that. It all comes out anyway during the title process. So it just stating that seller needs to disclose any of that stuff. And here is where that gets listed. So special assessments would be put here. Talk about what the dollar amount is, either if there is one or there isn't a proposed or pending special assessment. Here is special service area. So this could be like sometimes municipalities will have paved a road and charged a special service area fee to the tax bills for that area. And all this stuff kind of comes out during the title process anyway. But if you know about that, then we check that here. And then condo or HOAs. So that's the information goes here for the HOAs, association name, phone number, all that good stuff. And then 236 and 240. So D and E just talks about association assessment fees. So what the fee structure is. And then there's additional assessment fees. Like there's some properties you've had that they've been in like 2 HOAs. Like in townhomes, you'll see that it'll be so there might be a subdivision that has a HOA to pay for park maintenance and pond maintenance that every unit in there has, and then the townhouses in that area also have their own HOA for the grass cutting service and snow removal and things like that. So, all right, moving on to earnest money. So if we were to check this box and initial, that would be saying that the earnest money should be held by the brokerage. So that'd be like if, for my case, if EXP was holding on to the money, and this just states that what the brokerage can do with that money. It's basically this thing we put in an escrow account that would be held to go towards the seller's cost on the transaction. And then this is usually how we do business, is that in Illinois is very most common for this. The seller's attorney to hold the earnest money. So this is the box we usually check in initial, which just states that the brokerage maintains a policy of not holding earnest money. This would mean that EXP would not hold the earnest money, but that it would go, the seller's attorney would hold the earnest money. All right, we're getting to the end, guys, of this one. So we're getting there. 23 states that if there's amendments needed to this agreement, that there's, obviously, if you have one original copy that it gets signed, then that's contract's good to go. The amendment's complete. But sometimes there might be a reason that, like, say, a buyer and seller, or the two sellers sign separately, like one's out of town or what have you. And so if you have print 2 originals of amendment and you have seller 1 sign this one, seller 2 sign this one, that then you put them together as there's 2 physical different copies, but together it makes one original. That's just stating you can combine different ones to make one original. Mediation just talks about that any controversy or claim rising out of this agreement to the breach to be remediated in accordance with the rules pertaining to American arbitration associations. I've never experienced anything going to mediation, but just has language in there in case something came up. Indemnification, section 25. This section I always get a chuckle out of because it basically states that the seller agrees to indemnify the brokerage, managing broker, and designated agents, like me working for you, unless this last section, provided the brokerage is not found to be at fault. So as long as they're doing our job, then the seller indemnifies us for anything, unless we didn't. So that's what that section says. All right, 287 disclaimer. Yeah, disclaimer states that the real estate brokerage is acting as solely as real estate professionals and not as tax attorneys, tax advisors, anything else. So it's just stating that, hey, we're there to help you sell your house. We're not experts on the other items. We can help provide references to those other vendors, but that's just stating the disclaimer of what our roles are in the transaction. All right, 27, cost of third-party services or products. It states that seller is responsible for the cost of third-party, such as surveys, soil tests, title reports, well and septic tests. And so we'll help you navigate, getting the best pricing for anything like that. But, like the attorney that you need to represent, something the seller pays for, title reports, what have you, all that good stuff. All right, lease of property. This states that, although the intent of the agreement is to bring about a sale, option, or exchange of the property, that sometimes the property will end up just being leased. And if so, then it just states what commission amount the brokerage would be entitled to if a lease resulted from this from the listing period instead of a sale. So I've never experienced that come up, but that's what this section states. All right, severability. This just states that if one section of this agreement is found to be invalid, then just that item would be thrown out and the rest of everything else would stay in effect. All right, section 30, notice. So this section states details of communication. So this states that if, say, there's multiple people selling, like it's 3 brothers that inherited a property, that notification to one serves as notification to all 3, and how those notifications happen to be by personal delivery, so like in-person conversation, mailing of such notice by certified mail and return receipt requested, sending facsimile transmission, talks about business hours that needs to be done, sending email, and so email works and talks about business hours that count, and that the recipient would need to provide written acknowledgement to the sender. So you'll see that a lot in real estate transactions. The email will go out and be like, please acknowledge receipt of this communication. And then somebody would just respond, received, thanks, or something like that. And then by commercial overnight delivery like FedEx. All right. So moving on to entire agreement, which states that this agreement constitutes the complete understanding and entire agreement between the parties relating to the subject matter, and that any other whether oral or written other agreements have been merged and integrated into this agreement. So as your agent, we provide way more level of service than what this agreement states, but that's what this is saying, is that the standards of expectations is all listed in here, and that this agreement may not be terminated or amended prior to termination date without express written consent of both parties to this agreement. All right, so now almost there. So 321, 322, seller hereby acknowledges receipt of a signed copy of this agreement and all attaches. The attachments included the following. So very rarely are attachments included, but there could be. And then this just goes through the signature. So my managing broker, he would sign this by his name, his signature, the date. Designated agent, that'd be me. Date, our office address. This is my cell phone. My email, seller signature, current mailing address of the signature, date, phone, and fax. So that's all the information that goes in. And this kind of, this will be real quick, but on every single page, both sellers, if there are 2 or sometimes there's 3, we just add a box, will initial every single page, as does the managing broker. Anywhere there's an initial box, it gets initialed. And so every page is getting initialed, and then at the bottom it gets signed. All right, so now we're going to move on to the disclosures. So the first disclosure queued up here is, actually before doing that, let's go to the MLS listing exemption authorization. So what this basically states, the spirit of this is that what happens often is that when you fill out listing paperwork, that it states here that within 48 hours of the effective listing date, then we're supposed to, as agents, are supposed to have the listing in the MLS and, advertised to the general public. And so a lot of times what happens is that when we sit down to sign listing paper, it might be like a week before the house is ready. And we want to get everything signed and dated and whatnot so the paperwork's good to go. But this form gives us additional time before we put the home on the market. So the spirit of this exemption just talks about, the different, it just makes it clear for the seller as to what they're signing. And so we'll go through this pretty quickly. The home address, the date of the listing agreement that would have just been signed is listed. The broker's name, owner's name is put in here. This just states the purpose of the MLS, that, our Chicagoland MLS will feed this property to nearly 45,000 real estate professionals. Mandatory submission. So this just states that how it works is that we have to have the listing submitted to the MLS within 48 hours of the effective listing date, or within 24 hours after the real estate broker advises the real property to the general public through websites or utilize public accessible print advertisements. Yes, so if a sign goes in the yard, then it has to be in the MLS the next day. And so if we want more time than that, then we have to fill out this form. But with that, it's kind of like all or nothing. So if we're not going to, so like a sign in the yard would have to wait until we actually put the house in the MLS. So, and it gets in the weeds a little bit there. But this basically does, again, this lets us fill out the paperwork so that we can get the listing moving along. And then we'll just, once the house is ready, then we can just finish the advertising process by getting it in the MLS, putting the yard signs out, all the directionals and all that good stuff. It's exposure to buyers and renters through the MLS. So again, this kind of is a little bit of a repeat of stating that, through the MLS, we may further transmit the MLS database to internet sites or apps that post property listings online. Broker duties are basically repeated from the listing agreement, that as an agent, the realtor, we have to respond to other MLS participants and customers, and that we would provide the minimum services required by law to the owner. So a lot of this is repeat from the main agreement. Realtor Code of Ethics. This talks about, it's a lot of repeat from the earlier agreement, that we would, and that we would cooperate with other brokers in making our property available for showings. Again, this goes into just details there. No additional fees. States that by using this form, there's no additional fees. Impact of exclusion from the MLS. So this just states that, hey, if you don't submit your home to MLS, then it's not going to be distributed to all these different websites and different marketing online portals, and the other brokers won't know about it. And again, we just use this for a little time extension. That's just letting signing off on the seller, understanding what the impact is. Fair housing. This is a repeat of what was in the contract earlier. So it just states you won't discriminate against the protected classes. Seller opt-outs. This is just where we fill out how much time we need. So we usually check this one. It says do not submit property to MLS until further written notice. And then so once we're all ready to get the home on the MLS, then I would just email you and say, like, please confirm that we're ready to go to list the house in the MLS. And then you just reply, yes, we're good. Or, you could call or what have you. Then otherwise there's options of, hey, don't submit the property for X amount of calendar days, or until such a date, or until certain milestones have been met. And that's actually one that we use sometimes too. And then this one, do not submit property to MLS during an entire listing provided in the agreement. I've never used that one. I could see how that could be used though for private listings. Sometimes that comes up. All right. So then owner signature address, owner signature address, real estate broker, managing firm, all that good stuff. So that is the MLS listing exemption authorization. So now we're going to move on to the disclosures related to the property. So we got the residential real property disclosure report. So what this goes through is talks about the different items of the house. And so you as the seller would go and check each item here. And so what this goes through is you'd click yes, no, or not applicable for these various items. Sellers occupied the property in the last 12 months. You currently have floodplain hazard insurance on the property. I'm aware of flooding or recurrence leakage in the problem. So I won't go through each one. You could read through them. I'll just scan. Sometimes some of these are a little confusing. So floodplain, that's stuff they can help you with on that. Foundation, basement foundations, any leaks in the roof or ceiling or chimney. If you're aware of material defects in walls, doors, or floors, material defects in the electrical system, defects in the plumbing system, defects in the well or pump, unsafe conditions in drinking water, defects in heating, air conditioning, ventilation systems, defects in fireplace or wood burning stove, defects in septic, sanitary sewer, other disposal, unsafe concentrations of radon, and there's another disclosure for that. Unsafe concentrations of asbestos, unsafe concentrations to lead paint, basically lead items, and again, there's another disclosure on lead. I'm aware of mine substance, underground pits, settlement, sliding upheaval. I've experienced one house that had a huge void under their garage floor, which is kind of interesting, but that was years ago. But otherwise, I've never seen anything with that one. I'm aware of current infestations of termites or wood-boring insects, structural defects from termites or other wood-boring bugs. Aware of underground fuel storage tanks on the property. I'm aware of boundary or lot line disputes. I received notice of violation of local, state, federal laws regarding this property, which violation has not been corrected. So if you have been notified and you remedied it, then you don't have to click yes. But if you have something pending, then you check that. Most common I see this is local will be like a building permit that was never closed out. Most sellers don't even know they weren't closed out until we check with the town. But that's that one. And then I'm aware this property has been used for the manufacture of methamphetamine. And so that was something. That's on a question on all properties, I think, throughout the U.S., because in Indiana, there's the questions there, too. All right, so then, so you just sign off on this. This just goes through definitions of the disclosures. I won't go through that. And, all right, so next disclosure is disclosure from radon hazards. So with here, this basically... the part that sellers need to be concerned with is this part, so seller's disclosure. And so if you know about elevated radon levels, then you would click here and then you give an explanation. If you have records on elevated radon concentrations, then you would click here. If you do not have any knowledge about elevated radon concentrations, you click here. If you have no records or reports pertaining to elevated, you click here. So like 99% of my listings, the sellers check this here. They don't have any records and they don't know of any elevated levels. So then we get into purchaser's acknowledgement. So at the listing, we sign all this and then we attach this form to the listing. And then when offers are submitted, then the buyers have to take this form and then they sign off on this. And that's actually, I didn't say that on the residential, this one is that for the property disclosure is that the buyer will do the same thing for this one too. They will, when they submit their offer, they have a copy of this disclosure and then they'll sign it and submit it with their offer. So going back to this one, so then the purchaser would say that they've received copies of any information if it's available, and they have received the ADON approved disclosure pamphlets. That's something we just include in the listing. So they have just standard information about radon. And then here is agent's acknowledgement. So that's just agent has informed the seller of obligations under the law. So doing that right now. So I check that one. Certificate of accuracy. So seller signs, dates, purchaser, agent. So that would be me as listing agent. And then the buyer's agent signs here, property address here. Okay, cool. So now we're on to the last two forms. And these are disclosures that are specific to the real estate brokerage. Like every real estate brokerage has these basically two disclosures. They say generally the same thing. This one here is basically stating that wiring fraud is bad. Be careful about it. And yeah, so here's just the safe practices. Never obtain phone number of escrow officer at beginning. No, obtain. You want to obtain the phone number of the escrow officer beginning your transaction. You never wire funds prior to calling on your escrow officer to confirm wiring instructions. Only use a phone number you were provided previously. Do not use any phone numbers included during in the emailed wire transfer instructions. Yeah, so we never get wiring information via email. Sometimes they'll send it through secure portals, but not like a regular email because those can be spoofed. Actually, that happened once where a buyer was getting ready to buy like a $350,000 house. They were buying it with cash, and then the day before, they got an email from what looked to be the title company it said like revised wiring instructions, and it was actually somebody spoofed the email, and if they wired it, that money just would have been gone. So you want to make sure you get the wiring instructions directly from the title company or the attorney, and you would do that via a trusted phone number. What's actually best is just to go there and they'll print them off for you and then you bring that instructions to your bank. And it just states that you want to orally confirm the routing numbers and other numbers. Avoid sending information on email or text, again, because those can be spoofed. And take steps to secure the system you're using with your email account. Yeah, so these are kind of obvious ones, but that's a standard disclosure for pretty much all real estate transactions. And so then seller signs, buyer signs. All right, and then the last one we have is the affiliated business arrangement disclosure statement. And so what this basically states is that eXp Realty, they have a business relationship and or they own other businesses in the real estate space. And so which ones are is Intraland First Cloud LLC for mortgage financing. They also own Silverline Title and Escrow, and eXp is a subsidiary of eXp World Holdings. And so these are different companies that eXp owns or is a parent or sister company with. And then also eXp has a business relationship, but no ownership in America's Preferred Home Warranty Company. So this is the warranty company that we usually refer. And since they have a business relationship with eXp, they're very responsive and we know their policies well. And they cater towards eXp transactions. So we usually refer to using them. There's other warranty companies that are great too. And this just states that, you're not obligated to use any of these vendors. And if you don't want to use them because eXp has a business relationship, then you don't have to. And so this is just disclosing that. And again, so these are the names: Intraland First Cloud LLC, Silverline Title and Escrow, and then seller one, buyer one. It goes on the 2 pages. All right, we made it through. It was a little over 40 minutes. We got through all these the nuances of what all these forms are. And again, having gone through this will just save you time when it comes time to actually filling out the listing paperwork. You'll have understanding of what all these documents say. And then if you have any questions ahead of time, feel free to reach out, or you can save them for the time that you're actually filling out listing paperwork. All right. Thanks, guys. We'll see you on the next one.